May I now call on Mr. Anand Narayan to give his presentation.
I may probably need the HDMI cable. This is the HDMI. So. Yes, no. Yeah, there is a loose connection, I think. What is the loose connection?
लूज तो नहीं होगा, पर रेजुलेशन का फर्क होगा
इसमें।
रेजुलेशन का है कुछ प्रॉब्लम।
Resolution. This is good. Or should I just reduce it? Reduce करना पड़ेगा।
कम करना पड़ेगा।
Okay, so just while we get that synchronized, I'll request Ria to just move up in the batting order, and then Anand can be the tail ender. Thank you.
Great, thank you. I was very conscious that I would be the sole person standing between everyone here and lunch, and I'm happy now that responsibility has been passed on to Anand. It's a great honor to speak on this panel again, amidst distinguished and really interesting guests, and it's also a very high bar to meet. So I hope what I'm saying is interesting and valuable. What I'm going to talk about today is in line with Apar's approach, just looking with some granularity at just one aspect of the bill, which I have a little bit of experience in. Privacy impact assessments. Now, privacy impact assessments are an established part of privacy governance. It's also, impact assessments as a kind of governance tool exist in other fields also. They've come from environmental law. There's also calls to include them in looking at the impacts of algorithmic projects or algorithmic, anything that uses an algorithmic process. There's also calls on, within the field of business and human rights to look at what are the human rights impact of any proposed business. So the field is sort of established. What I'm going to draw on today is my experience conducting these assessments for international organizations, where I've looked at how they are operating in other countries. So, and I've had the privilege of going to refugee communities in Cox's Bazar to understand what is the impact of the kinds of data processing that a particular organization is conducting, and what is the potential risks and impacts on the community that is being that they're working with. And I've done similar assessments in different parts of the world, in Nigeria, in Sri Lanka, and the Philippines. So what I'm wanting to just think about a little bit is what does the law here say about impact assessments, and what could it look like based on my experience. So within the world of data protection, PIAs, like I mentioned, exist, and I'm going to use PIA as a sort of short form for these impact assessments. The idea is that it's an approach of risk-based compliance, and how do you make the data controller, or like we have in our bill, the data fiduciary, take primary responsibility for understanding, okay, what is the impact of the proposed data processing that I'm going to carry out, and how do I take some responsibility for the potential harms that could arise from these impacts. This exists in the GDPR, Article 33 mandates TPIAs, but I'm not going to go into that much. Clause 27 is what I'm looking at here. That's on page 24, if you want to look at it, but I'm not really going to go into the act, but let's see what the process looks, what exactly this is. So it places an obligation on significant data fiduciaries, and significant is defined in the previous laws in 26. And for certain types of processing, where there's going to be, a processing involving a new technology, large-scale profiling, or the use of sensitive personal data like genetic data or biometric data, or any processing that carries a risk of significant harm to data principles. Right? All of these, of course, have to be unpacked in due time because it determines who, in the first place, is required to conduct an assessment of this nature. I really want to talk quickly about what that process looks like. Right? And this clause looks at it in section 3. Right? So there is an impact assessment that has 3 stages. You really understand what is the proposed processing operation. The second is, what is an assessment of the potential harm? And finally, you try and figure out what are the measures for mitigating this harm. Once it's completed, what happens to that report, right? And I often worry the reports I wrote have just gone into someone's inbox. They're too long. Nobody wants to look at them again. And that's a real concern, though. In the law here, it's vetted by the data protection officer, and then who submits it to the data protection authority in a manner as may be specified in regulations that are yet to come. On receiving the assessment, the authority is supposed to be satisfied that if the processing is likely to cause harm, it may direct the fiduciary to cease the processing or subject it to conditions that may be required, that may be specified under regulations subsequently. Right? So this is broadly what it looks like. Now, I want to just talk a little bit about my experience conducting these kinds of assessments, right? So, like the law says, it's a fairly straightforward process. You conduct a kind of threshold analysis. You map out, okay, where is all your data? Who's collecting data? What kinds of data are you collecting? Then you understand the context. And because the exercises I've done have been in other countries, you look at the laws, you look at the, also the rule of law. What is the quality of actual application of these laws? What are the kinds of surveillance oversights? What kinds of, how likely is it that data goes from one department to another, that sort of thing. Then you consult with beneficiary communities, which is something I want to talk about a little bit because that's the most interesting part of this exercise, and I think that's something that it doesn't exist in the law as it stands here, and I think it has immense, a lot of learning could be got from that process. And then, you map, like I said, you use all of that to highlight the risks, and then you work with the organization to develop the mitigation measures. So I want to talk a little bit about, what the engagement with communities has looked like. That's been the most interesting and a big privilege, honestly, to go into a community and say, look, we collect all of this kind of data, and I want to understand what this means for you, what are you understanding by this, and what kinds of concerns do you have around it. In 2019, I went to Cox's Bazar for a few weeks, and I was working with, so Cox's Bazar is in Bangladesh. It's the longest beach in the world, apparently, according to their PR. It's very beautiful, and it's also one of the largest refugee communities of Rohingyas who have come from Myanmar. There's a lot of humanitarian organizations that are providing these communities with support. So it was one of those organizations that asked me to conduct this kind of assessment. What I was doing is going to these communities, asking them, this is the data we collect about you in order to give you assistance. What do you feel about it? Is there anything about this that is concerning? Now, I go see this in English, it means nothing to people, right? Rohingyas speak not Bangla, they speak the Rohingya language, and so it took work to even translate the concept of privacy into the local language. That there wasn't also a straight analog. So we had to think about how do you make this concept understandable. Of course, one of the things this taught me is it turned on its head the entire idea of privacy being an elitist concept and people not knowing, because immediately, sure, if you say privacy, people are like, I don't really know what you mean. But the minute you say, think about it, think about the idea of sharam, right? And sharam was also a Rohingya word. Is there something that you may not want other people to know about you? You may not want your, your camp leader to know. You may not want your husband to know when you're working with, groups of women. And immediately people start thinking about it and saying, oh yeah, that's right. Maybe I don't want my camp leader to know where I'm employed. Maybe I don't want, maybe I don't want my neighbor to know whether I'm pregnant or not. So these are all really interesting things. So, Apar pointed out how sensitive data, has been defined, and that category could be expanded also by regulations. But there is an idea that sensitive data is a very contextual analysis. It's a very contextual feeling of what you feel is important to you, is sensitive to you. And that's what these consultations really made me understand. I wanted to just talk about also how tenuous this process is, because you go in with your own ideas. And if you ask people straight up, okay, we collect these 5 kinds of data about you, but we give you, some food assistance in return. Do you have a problem with that? They'll say no, because it seems like that the assistance they're getting is contingent on them accepting to hand over that data, right? And that's something that these consultations also have to try and turn on its head. Now social science has a lot of guidance around how do you go into a community consultation as an ethnographer, bringing in your own biases and trying to understand what people actually feel. Of course, this is a fast stretch. It's a heavy burden to place on lawyers, but it's something that just to be sort of aware of. Something that came out of these consultations is also really understanding the texture of consent, right? What does it actually mean when people consent to handing over their data? And, like Apar said, the bill is based around the idea of consent. I think I've looked at the Aadhaar, project in quite detail, and there was consent camps that were held, where it was like, let's gather people in and tell them this is what we're going to do. Do you consent to this? Yes or no? Yeah, okay, great, we've got everybody's consent. In actually Cox's Bazar, a few years after I was there, Human Rights Watch released a report where there were allegations that the government, the host government, the government of Bangladesh had handed over data of refugees to the government of Myanmar. That's deeply, very, very scary. That's an immediate kind of harm that could come out of that. The data collection process that UNHCR relied on was a tick box for consent, saying consent to share. That's fine. Human Rights Watch did interviews with people on the ground and said, okay, 23 of 24 refugees that they interviewed said they were never informed that the data would be used for anything other than establishing aid access. One person said that he only noticed on the way out that his form had a tick box that said, okay, consent to share has been ticked. Right? Another person said, I didn't feel I could say no because my smart card, which is what you needed to get your assistance, dependent on that, right? So these are the kinds of things that would come out of your community consultations, right? What do people think is sensitive? What kinds of harms do people envision out of sharing or processing or handing over their data? And also, do people feel coerced or do they actually feel comfortable to hand over this data? Now, when coming back to the PII process, then what? How do you convince your client or the organization you're working with to change, their business model? There could be commercial interests coming in the way. There could be, there could be just efficiency problems. One of my colleagues here pointed out there's massive cost implications for these kinds of detailed exercises. So it's a challenge. I think it's a challenge as a lawyer. You have to get used to being unpopular amongst your clients, so you just have to be, you've done this, it doesn't look right, you have to change your way. The second challenge with this whole PIA process is that it turns on this harm-based approach, and harms are not, you can't envision all harms, right? Especially in the field of data, data privacy, you can't adequately, there's some kinds of physical harms, maybe from like say this idea of handing over data to a country that has persecuted you. The harm is quite evident from that, but there's other kinds of things that you can't fully envision. How do you arrive at this? You can't only rely on the person you're taking the data from to say, well, I'm worried about ABC, and you can say, okay, that's fine. Because you also have to, like, there's a, I guess it's a public health term, you have to triage your insights from what you hear from the community, and also the context that you're operating in. Say, if you're working with a business that works with medical data, what kinds of regulations are there over insurance companies, and can they get access to this data, right? That will determine the types of harms that could arise out of a possible data processing exercise, right? So this is just to encourage people who are conducting these kinds of exercises to think quite broadly around harms. Finally, I just want to sort of finish with what a bad PIA looks like, I think the worst kinds of PIAs do a kind of compliance checklist approach. Have you done this? You're great, go ahead, everything's fine. There's a few challenges with this. Actually, the Canadian Privacy Commissioner offers really good guidance around what a privacy impact assessment should look like. And one of its small, very pithy guidances is, it is not a checklist. It can't just be something where you just say, have you complied with these laws? You have to really go deeply into it. It's an ongoing process. An interesting PIA that I've read was issued by the Nigerian government to look at their equivalent of Aadhaar. It's called NIMS. It's a National Identity Management Solution. I think that's what the S is. But they did this kind of impact assessment. They said, okay, there are these potential problems with privacy, but overall people seem to agree you need it, so it seems all right. Is biometric data a problem? No, it doesn't really go into your body, so it's not really a privacy risk, and so that's okay, right? Not very rigorous, not very, it doesn't inspire a lot of confidence. I went to Nigeria last year and I realized I could not get anything done legally without a national identification card. And so it was a bit difficult. I was like, I'm here for 2 weeks. I don't think I should get this card. It took me 5 minutes on the black market to get a SIM card. That circumvented a lot of these things, right? Now, that is an exclusionary harm right there, right? And that's not something that was captured in their PIA. There's other kinds of, harms that may not adequately be captured again when we're talking about big public projects or e-governance projects. One is, of course, the exclusion harm. The other is, what about the cost benefits of pivoting to this kind of technological governance mechanism. I won't go deeply into that, but I'm just going to wrap up now in the interest of time. Overall, I think the reason that these kinds of impact assessments is interesting and important is it pushes forward an idea from environmental law around the precautionary principle in what companies and governments are doing with data, right? That you have to have the person or the entity proposing to do this kind of processing has to take responsibility first to identify and prevent the kinds of harms and risks that could emerge from this. I think it's an important thing to hold on to, right? Because it also goes to, what Mr. Divan said at the beginning, that it's a way to introduce friction into this process that turns on its head a little bit the myth of inevitability of the kinds of very data-intensive or technology-intensive processes that we're moving towards, right? So that's why there are two reasons that I think it's quite interesting. But I want to end with just some questions around, what is potentially wrong with the PIAs as laid down in Clause 27 right now. first is who will be included, right? And looking at how EIAs have, have progressed over time, and we have a lot of robust learnings from how they've been implemented, is a lot turns on who is defined, what kinds of projects need to have an impact assessment. So I think a similar kind of question here. The UID I wrote in October 2021, and it was quite sweet actually, because they said, can we be exempted from the data protection law? There was a news report, I don't know, again, I didn't follow up on that. But, that was just the kind of thing that seems like, maybe that's not a great idea, because it is the largest data collection exercise. The second is accountability, right? Like I said, I worry my reports are just sitting in someone's inbox, not even printed out and whatever. But you need these reports to be actually acted on. The organization should be held accountable for it. And also the consultants' work should be checked. I think around EIA jurisprudence, there has been some questions around consultants for hire who will come and just tick off your project and say everything's fine. Yeah, and I'm just going to end with, public consultations and transparency is key. Because, there could be some kind of requirement to publish these impact assessments, so other people can know, okay, should I sign up for this? Let me see what are the potential harms and risks for that, around that kind of thing. So, yeah, and just one last thing. I thought it was really important what Apar mentioned about the lack of proportionality, across this entire text of the law. Similar case with the PIAs. There are other PIAs, there are other guidance that says, when you outline what the processing is, then you do a step around, is this necessary and proportional to your purposes, right? You're not a judge, you're a private consultant doing this, but it's an important check, right? To say, look, are you achieving your purpose? Can you do it in another way? And that's, it makes you unpopular, like I said, but it's an important thing to ask whoever you're going to be consulting. That's it. Thank you very much.
Thank you, Ria. Anand, over to you. I hope you're...
This works, otherwise I'm going to pay it impromptu. Okay, fine. Thank you. Just change the slides. Yeah, just change, right? Hi, so today I'm going to do something very different than other people. I'm going to talk about a lot of things that are outside the scope of law so that you understand a better perspective of whatever you're discussing about. This is going to be the topic map. I'm going to talk about intelligence agencies. I'm going to talk about surveillance systems, architecture and systems on the pre-smartphone era. I'm going to talk about them after the smartphone era. I'm also going to talk about some of the stuff that we did on surviving surveillance, right? So the most important problem that you see when intelligence agencies come and ask you, we want exemption. Why are they asking exemption? The simple problem that they have is they have a boundary management problem. So if you look at nation states, they are non-corporeal entities with boundaries. They have a lot of boundaries: land, water, space, electromagnetic spectrum, physical systems, cybernetic systems, and doctrine, reason for existence, quite a lot of them. Every one of these is in their head boundaries, which needs to be protected. In a way, it is very similar to how human beings think about boundaries. So we have our own physical body, relationships, values, whatever you call them. And these are boundaries that we know how to protect. So if you look at the boundary management problem, in general, we call this as a scale invariant property of complex systems. So any boundary requires watchers and defenders, and both watchers and defenders need analysis, data, intelligence to act, respond, react. And so this is the primary reason why they come and tell you that we need intelligence agencies. Now, the hard problem of boundary management, if you look at our own systems, is that we have our body immune systems. It just so happens that most of the body immune systems are not controlled by conscious thought, fully autonomous. And why is that? Because the existential threats for a boundary is very fast for the body. So the cells have evolved a system where it says that we have to operate on a very different time dimension, and that is the reason why they are not under your conscious thought. So now, the other problem with these kind of models is that they have autoimmunity, which is what we call cancer in the normal terminology, where the immune system attacks the body and the body dies. So if you look back and think about the intelligence agencies problem, why they should be under law, the problem has always been that they believe that they operate on a time scale that is much larger, smaller, and is not comparative to a human relationship. This is exactly what they believe inside. So they come and ask you saying that your procedures, your processes, and your systems are actually constraining us to prevent the nation state, so please give us exemptions. That is really the thought process that goes into framing those exemption conditions on the law, all right? And this is something that they will not come and tell you. This is something they will come and only tell you when you work with it, yeah? And of course, the problem with the boundary management is, how many of you are aware of the Praetorian Guard problem? The guards of Caesar, which basically turned the Roman Republic into an empire. So intelligence agencies are also manned by human beings, and they are prone to the same human being problems that you and me are prone to. So the fundamental structure of any democracy to bring intelligence agency into law is to prevent the Praetorian Guard problem, where they just take over the state and do whatever they want to do about it. Now, the trouble, of course, is how do you fundamentally put an intelligence agency in a law? How do you regulate them? And so this is the reason why many countries have passed laws which talks about secrecy and how to balance between secrecy and function with efficiency and so-called exemptions, et cetera, et cetera. The trouble, of course, you always know as a legal person is you can't oversee or you can't regulate what you don't know. And that is a fundamental space in which the agencies operate. And if you look back, what has happened is the rapid advancements of technology has essentially made oversight ineffective and redundant. This is the larger perspective of intelligence agency as it is today. Every lawyer in this room thinks that they actually know what the intelligence agency are doing. They don't. Believe me when I tell you that, right? So let's go back and talk about surveillance systems and architecture in the pre-smartphone era. This is what we call as surveillance ports in a telephone exchange. This is an official architecture document. So nowhere in the world you can actually sell a telephone exchange without inherent surveillance ports. So these diagrams that you see, 3 ports, this is where they actually go and tap, right? By law, every single procurement in this country, by every single telecom and ISP provider needs to have the surveillance ports. And this is the technology. You just can't buy an equipment and put it out there, right? And that is the nature of how the systems operate. And this is true even today. It was true in 2010, 2003 onward. So this diagram is probably in standard now, for whatever reason. And so in summary, what it means is all your calls belongs to them and all your SMSs belong to them. They just put the tap automatically. They just get it done. I mean, this is how the system works. And if you look back, this is the central monitoring system. So an interesting bit about this slide, this is actually a trade secret, and so it is freely available in the Russian internet. Okay, and why is Russian internet? I will come back to that later. This is basically what the services they could intercept with the CMS. Yeah. So you can see all of it, everything around it. Yeah. And this is again an official slide. Look at very carefully what they are coming and telling you. They're carefully coming and telling you that competent authority to issue the warrant. I think it's the Supreme Court of India, but I don't know, all right? But this is apparently what the process workflow works in their own official websites, which is warrant, management interface, and handover interface. And yet, you keep seeing this happening even as of last month, right? And why is that? The primary reason why this is because the system is fully automated. In theory, the warrant thing that anyone has in their head doesn't apply. You just need a local Thana person to call someone in their state department or state police and say, I want this person's number to be in the system, and it just works. That's it. This is pre-smartphone era. And this is why you keep seeing this stuff about like radio tapes, et cetera, et cetera. This is how it works. There is fundamentally no oversight here. In theory, it is. In practice, none, right? Let's go back to look at the other interesting component in the olden era called stingrays. These are machines like this, probably this size, right? And no one has ever seen it. There is again no warrant here. These are called drive-throughs. You just put it on a van and you just drive through Lodhi Road. You will get every single person's call details. I mean, the normal phone numbers. These are completely outside the spectrum of law. So this is how it looks. If you've seen it, you've operated it. This used to sell about $3 million in 2010. If you go to DEF CON, where I present my security conferences, this is probably available for $30. I once made it for my employer for about $10, which had which could surveil everything in a single room. I mean, this is so cheap. And this also they do a lot, yeah? I don't want to go and do this. And how well are these stingrays managed? This is how they are managed. You can see them being stolen. You can see them being taken out by corporate entities. MHA was seriously concerned about it at one point in time, and this is how they manage it. And the other interesting thing that they do is called internet junction boxes. So every single packet that flows out of the internet they just basically put a junction box, and they have like they used to have a 25 people monitoring team that just looks at every single packet going in and coming out of India and figuring out threats. Okay. These are official newspaper articles from which I put in quotes. And how well are the surveillance system managed? You can see that Punjab police lost 4 of them, and police do require, but in practice, they don't do any authorization. And this is the case of Amar Singh, what happened. And then the primary reason why this stuff happens is because these small units are managed by officers who are paid 8,000 rupees a month salary. So you can understand what the implications are, yeah? And this is just not an Indian problem. So if you look back the Snowden affair, remember this is still pre-smartphone era. You could see the NSA building X-key score, metadata surveillance, off-the-post interception is every time a Cisco router is shipped, someone basically intercepts it and puts a smart card in it in order to create surveillance. I have done several of these. Bulk data teleco warrants, you just get them CDR records in bulk. This happens a lot in India. There was even an article about 1.5 years ago about how every single person in the Lutyens, Delhi got the CDR sent in bulk to the MHA. You just have to look for it. Then there is encryption backdoors, where the NSA basically puts backdoors on the encryption. And then there is intermediary opt-ins for automated data sharing, biometric device driver injection, interception device and data center, a whole bunch of issues, right? And so if you look back as a technologist, when we were looking at it, of course, there's a lot of horrified opinions. What do you do with it? I mean, these guys completely operate outside the systems. They don't believe in following any due process. What do you do? Courts were not working. So at this point in time is when we went and said, forget about it. Let's encrypt everything, right? So it just so happened that nowadays we encrypt every web traffic. That is your HTTPS bank thing. You encrypt instant messengers. Every one of you use, I presume, one of Signal or WhatsApp. Those are completely end-to-end encrypted. So we ended up encrypting instant messages, voice calls, video calls, zero metadata design, no storing of contact list, burn down 0 days. So the last bit I would explain more on what burn down 0 days means, what Amnesty Tech and Citizen Labs do. And there is a reason why it is called Citizen Labs. And there is a reason why it is called Amnesty Tech. I'll come back to that later. So these were the countermeasures that the technical community took because intelligence is just purely outside the spectrum of law. And if you look back, what it means is privacy technology in general is about mathematical guarantees via encryption, is not based on law because the people whom we actually tangle with are intelligence agencies who don't work within the spectrum of law. And it is not based on oversight of institution. That is why we call privacy by design or privacy by default. It is not a legal concept. It's a mathematical concept, yeah? And this is exactly what happened after that. So this 2 sections is called the Draft Encryption Act the government of India tried to pass on 2015. Look at some of the interesting bit. Some people call it as a Daft Encryption Act. So look at what they were coming and telling you. They were coming and telling you that you have to store passwords of every plain text so that we can come and intercept it. And this is exactly what encryption did to them. It just made them, it just made citizens opaque to a large extent, right? They just never liked it at all. So they tried to pass it. They took it back because there was just humongous amount of pushback and fight. But this is their first reaction, right? Now comes the most interesting era. In the last 7 years, we have seen an explosion of smartphones. And so you look back and say, what is the surveillance architecture and systems of the post-smartphone era? This is how it looks. These are the broad principles what they operate on. When I say they, it is, again, the intelligence services. The first and foremost thing is they always focus on endpoints. Remember what encryption has done. Encryption has essentially made mass surveillance through intermediaries redundant. And so if you look back, the older systems like CMS and all, they don't have to come to the judge for a warrant. They don't have to come to anyone. They just call the telecom head and say, de do bas ho jayega, right? It's literally written on yellow slips. I've seen those things. So when surveillance orders are passed, it's literally an yellow slip that is written with the phone number and the name and say, dal de iske system ke andar. It's literally that. That's the warrant, right? Those things are now dead if you use encryption. And of course, they are worried about it. So they come back and tell you that let's focus on endpoints, right? Endpoints is your computers, your devices. It's much more harder, but encryption has basically made mass surveillance to a large extent very, very difficult. Hostage laws. So this is what is called nice organization you have there, pity if something happens to your country head. Yeah. So this is a very common legal tactic, right? Data localization, this is what China does, which is store without encryption or weak encryption, where I can seize it and summon it. Influence operations to weaken encryption. This is the British version, saying, look, terrorists here, child pornography, they're using, why are you using it, right? So that's another broad pushback. Outlaw encryption directly. This is the Australian version, which they basically said, laws of encryption are admirable, but laws are, Australia take precedence. It's kind of very hilarious if you look at it. Then outlaw encryption indirectly. This is the Indian version. Traceability mandate IT rules 2021. They basically passed this, saying that with every WhatsApp message, you should know the originating sender. Yeah, it is called as the Kamakoti idea. I've written papers about it, about how useless it is. And I will just say the way useless it is, because that is not how cryptography works. Cryptography does not work on wish lists. Cryptography works on mathematics. So they basically presented a wish list and saying, there needs to be a hare, and the hare has to have 3 legs, and it should win the race against the horse. So somehow get it done. That's what I call it. The government has basically set traceability mandate. Yeah, it's kind of very hilarious if you think about it. So the next thing they've done is focus on endpoints. I'll go a bit deep into it. So if you really understand malware from a technologist point of view, it's very different. But if you have to explain it in legal terms, one way to think about a computer program is it is free speech expressed in code. So just like you have language, semantics, rules, procedures, processes, and etc., we have computers whose language is made of microprocessor assembly instructions. You can literally write any sentence, just like how you can literally write any poetry or whatever you want with language. You can literally write any sentence, any language within the microprocessor, right? So that is why we call it free speech expressed in code. When people create applications, how horrible they are, they have a very different view of the free speech, but hackers like me have a very different view. So where you see utility, I see attack surfaces. And so who wins the interpretation battle is basically equal to who's the best advocate before the computer judge, right? I can tell you hands-on, it is the hackers who always wins against any utility writers, right? And so the fundamental way of an exploit is then, how do I make a particular program behave very differently? That is what is called as an exploit. One way to think about it is gaslighting the computer. It's literally gaslighting the computer, and we are pretty good at it. So 0 days is you give any utility or tool, your iOS, your phone. That is, we have tools to identify a vulnerability. Nowadays, it is fully automated. In the olden days, we used to basically pour through millions and millions and millions of lines of code to find one vulnerability and attack it. Nowadays, no, it's fully automated. We literally have programs that analyze other programs, which then analyze other programs. It's like a 3-way pipeline using AI and ML, which can identify vulnerability in any application in less than 15 days. That's how automated it is. Yeah. And so then what happens then is, we have invested so much on finding the 0 days. What do you do with it? So here is where things get very interesting. So if you understand vulnerability research, the one that we used to work on earlier, computer vendors don't pay vulnerability researchers a lot of money. So on an average, to find a bug in iOS, you may probably have to spend about $200,000. Apple will give you $50,000. Yeah, and that will happen in like 12 months or 9 months. So what do? You have a sustainability problem for your life, because this is what you do. So what you do is you actually sell it to a vulnerability broker. And the vulnerability broker is a person who acquires vulnerabilities from you and sells it to a nation state, right? I mean, so this is literally like an arms bazaar. Yeah. Just like how there are AK-47s being sold on arms bazaars, There are vulnerability researchers who actually find vulnerabilities, give a POC, we call it proof of POC, is like a proof of concept, and we sell it to these arms bazaar intermediaries who then accumulate quite a few of them and sell it to the nation state. And you got to work about, and the good thing about the arms bazaar brokers is that they give you quality guarantees, they have refunds, and then they also ensure that they take 30% commission on the price. So on an average, if you're a vulnerability researcher, you may probably, rather than selling it to Apple, just sell it to these guys, and they would give a pretty good premium. So on an average, an iPhone vulnerability on the arms bazaar sells about $1.5 million, while Apple pays $60,000. So you can just imagine the spectrum of problems here. And zero-day brokers are legal, and they even have a website. You can go look at it. This is where we found all the iPhone vulnerabilities. Yeah, I'll come back to that, why it is interesting. So this is what happens on 2011. This is a story that ran about stingrays in Hindu on 2011. You can just read this, and if I had not told you the day, you would have probably said the same thing about Pegasus either. Yeah, it basically says, well, Israel is one of the top countries which buys and sells. So in reality, what happens is, you're a vulnerability researcher, you have a particular skill to trade, you sell it to the arms broker sells it to the state of Israel, and then everyone buys from the state of Israel. This is usually the weapons pipeline. Yeah, right? And so I'll come back to the investigation I did. So two interesting people in my contact list were in the Pegasus thing, quite a few of them. One close friend, Saikadita, one acquaintance, Siddharth, in the list. Technical analysis was inconclusive. So his phone actually got bricked when I was talking to him. So it is that bad, yeah? So we were working on the story on the Kodamkar nuclear plant. Somewhere around the time his phone got bricked. When I said phone got bricked, we were talking and we were working, and his phone went just up, right? And we were like, okay, what just happened now, right? And so from the time I was pretty interested. So when his name came on the list, I said we had to do something about it because we can, right? And we had also investigated quite a few of the incidences on black markets and arms bazaars and stuff like that. So we said we'll have to think through something about it. So I got two phones in my hand, both Siddharth's, who was the editor of Wire, and Sushant, who's currently in CPR, but who was then a NatSec journalist writing on Rafael, I think. And so what is very interesting is there were two fundamental problems that came on the Pegasus investigation. First, was it malware? And how do you know it is Pegasus? And who did it, right? Three important questions. So for you to understand, was it malware, it's much easier, at least in the iPhones. Every iPhone actually has an immutable database starting from the time in which you bought the phone, which has every single application that you ever ran with timestamps, every single application. So if you look at your iPhone, it probably has about 75,000 entries, which had every single app you installed, when you installed, what you had. The database is immutable, in the sense that even if Apple wants it, it can't touch it, it can't delete it. So in this particular case, what Pegasus did was, 2015 was the first time they bought 3 vulnerabilities from the arms bazaar called Trident, right? So you have to chain them together in order to enter the phone. I mean, we had receipts for it. So NSO, the particular organization, was very interesting because they've been buying a lot. NSO was the #1 player in the arms bazaar market to buy a whole bunch of vulnerabilities targeting the iPhone. So every one of those things we have receipts and so on and so on. So it's much easier for you to, and then when those vulnerabilities are deployed, companies like Apple, Google, and a whole bunch of cybersecurity companies also do defense, right? So when vulnerabilities are deployed, they analyze it, they put out stories, they put out saying what is the mitigation measures. And just like viruses, just like real viruses, computer viruses written also have a lineage. Like, so you could track the lineage from alpha, beta, gamma, Omicron, BA1, BA4. We could also track computer 0 days from version A, version 1, version 2, this happened, that happened. So the whole sequence was actually available to us. And this is the work of Citizen Labs. So literally what they do is, they look at the 0 days and vulnerabilities sold in arms bazaars and actually put it out in the public domain and burn them. So when you put it out in the public domain, what happens is, cyber defense communities basically figure out the countermeasures and sell it back to the vendors. which forces them to fix them. This is what is called zero-day burning. So you can see this entire spectrum of how it works. It's outside law, right? And hence, normal recourses can't be taken using law. So we also operate on a very different time scale. That is how the system works, yeah? So this is what we did. I basically went and analyzed every single data point out there in the last 7 years, how many people got infected, so in this particular case, what happened was every time Pegasus launches, it launches under certain process names. So your process names are basically your app names. So if you look at a normal person's phone, you will see a process name called Ola Cabs or Uber, et cetera, et cetera. Every one of those process names have a back reference to the Apple iStore app, Apple Play Store app, right? But in the particular case of Pegasus, you would not see those back references. You would see those weird process names. It could be called ABD, CBD, OBD, and you could not find which application launched it, and you could not find a reference for it. So then what you do is you capture it live, and then you disassemble it. Then you understand what is going on. Then you check with the cross references with samples available in the Arms Bazaar markets. And so this is like a 6.5 year process. And there are like hundreds and thousands of places where this has been documented, because this is something that we do for a living, for patching systems. Because if you're working on a corporate side, how do you know your client is not sent a malware? So there is a big malware database which has all the characteristics, just like how you have a virus database, just like how we do genetic sequences of viruses, we do genetic sequences of malwares, and that is how the patch management works. Find, patch, find, patch. So what I found on these guys' 2 phones is pretty much matching what we found in the malware databases. It's actually as simple and straightforward as that. If I could have my computer, I could demonstrate in about 2 minutes. It's that simple, yeah? So this answered the question was that malware and was it Pegasus? Then who are the 2 confirmed buyers? Surprisingly, in October 2019, when the first WhatsApp thing came, me and Saika talked to some folks inside intelligence, and we actually got confirmation off the record that they actually bought it. So we know there were 2 buyers. And the way in which these systems work is that one system is probably this room big. So it's not some app. It's kind of very hilarious. People think of it like an app. It's actually a very big hardware system with, which is probably half of this room big. So it has a physical presence. Every one of the system can only attack and hack 50 phones, not more, not less, because it's like a hard-coded limit. So they bought 2, which means they have 100 slots. And this is basically rented out to all those agencies. Like you have 100 slots, pick one, add one, delete one, add one, delete one, et cetera, et cetera. And this is where it gets things very interesting. The entire database of Pegasus got leaked from another subsidiary selling location access called Circles, I believe, and that's the common consensus. So if you understand Pegasus, how it works, the first thing that you have to do before hacking anyone is, where are they? That is called location access. That location access is sold by another N0 subsidiary called Circles. And this is something that people use a lot. The entire database of the 50,000 numbers, people come and ask where it leaked from. The most likely consensus is either it was hacked or it was leaked from this subsidiary company called Circles. That is the most common consensus. We don't know for sure, but this is basically where it is. But here is another interesting thought for you. Because of the mindless mixing of domestic and foreign targets is the primary reason why this got exposed. So while intelligence agencies come and say national security, believe me when I tell you that their operational security is a horrible nightmare, as I had explained before. They keep losing equipment. In this particular case, they used it for Imran Khan, and they used it on Gagandeep Khan, right? From a pure operational security point of view, this is what is called as the worst nightmare, because one is an adversary and one is a researcher doing someone else. And if you use the same tool on 2 people, of course it's easy to do who did it via cross-correlation, right? That is how idiotic this whole thing is, yeah? So now, just to answer a different question, malware is not interception. So let people get it again. Malware is not interception. This is not stingrays. This is not phone tapping. So we discover on average about 100 vulnerabilities in one popular product. So if you just go look at Google Chrome, probably 200 last year alone, right? And it's very trivial nowadays to buy an exploit and custom-made malware for $50. It's really that simple. And offloading infection of malware to third parties, outsourcing intelligence function, in my opinion, is outside all constitutional norms. If malware in this particular case is used for planting, which I explained to the committee, this is like Destruction of Evidence Act root and branch. I don't know. So in my opinion, PUCL judgment is probably now light years behind. This is where we are. And so I'll come to the final part, and I think we'll just almost there on the lunch. So how do you survive surveillance? We used to think as technologists that encryption is a solution, but of late I'm seeing this where the Supreme Court basically said you should hand over your passwords. I don't know, right? Hyderabad is known where cops stop you on the road and say, open your WhatsApp and give it to me. No warrant, nothing, because they just simply, do whatever they want, yeah? So this is the problem. Now I don't know what to do about it. And so one option is, we used to run this training program for journalists on conflicts where they come back and say, well, if you're under surveillance and if you're going to a hostile regime, you have to behave like an intelligence officer. There's a whole bunch of procedures and process around it. And that includes having a lot of phone numbers and a lot of email IDs. I myself have about 14, 15, and about 140 email IDs. Well, even as a training program, it was pretty hard. I don't think it's worth it, personally speaking. So now what do we do? So if you look back, some of the problems that I told you, concerted push on surveillance reforms. I think we really need to mark red lines. Legal helps a lot. And that is one of the reasons why the Pegasus papers were where they are, where we figured out that we have much better chances of pushing these regimes back by passing laws in certain jurisdictions to push it back, rather than just only doing pure countermeasures on technology. It doesn't really work, yeah? Forces accountability. Most surveillance is just plain useless for intelligence, I can tell you that, right? The sheer amount of data they gather and what they throw and the kind of models they have are pretty much useless, yeah? Forces transparency, no broad exemptions for intelligence law enforcement, better oversight than now, which is zero. These are the broad things that can help. And I really believe it's time that people take a bit more time to think about what bringing intelligence agencies under laws mean, because I think at this point in time, my concern is they are both useless and dangerous. I'm not very sure whether it is a good combination to have, yeah? Useless in terms of preventing foreign threats, dangerous in terms of curtailing citizen rights. I think that's a deadly combination. Well, if only wishes were winged Pegasus. Yeah, right. Thank you, I'm done.
Thank you, Anand. That was really fascinating. I'm not going to try and do a wrap on this because we are way beyond time, and I think each one of them has so succinctly and summed up their position so well. So I'm just going to leave you all to draw your own conclusions. Thank you very much. And Anindita, would you like to just tell everybody?
Thank you to the chair, thank you to all the speakers, and thank you to the lovely audience. It was truly educative. At least I learned a lot. Now it's time for lunch, and instead of having 1 hour break, I think we should reassemble in 45 minutes.
Anand, that was really